Good afternoon, and thank you for joining us today. I would like to welcome you all to the first part of FortneyScott's 2026 Workplace Legal Compliance webinar series entitled What to Expect from EEOC. Today's presenters are FortneyScott attorneys David Fortney, Leslie Silverman, and Anita Beecher. This webinar will be recorded. I will now turn the program over to David to start the webinar.
Sarah, thanks so much. And Nita and Leslie, great to be with both of you today.
Good to see you, David.
Interesting topic for today, David, especially after the last week or so.
Absolutely. I mean, we couldn't start more timely. So what we're trying to do, folks, is in the first quarter of the 2026, we want to really kind of take a pause point, look back on the key federal agencies and developments. We're a year into Trump 2.0. And today we're going to kick that effort off with looking at the EEOC, and we couldn't have better subject matter experts than Leslie and Nita to do that. Let's just say a word about who we are for those that don't know. Of course, we're a law firm based here in Washington, D.C. Our practice focuses on compliance. We represent employers, certainly before the EEOC, as well as other agencies. We have significant experience and expertise, including Leslie, who formerly is the vice chair and commissioner of EEOC, and frequently works as a monitor on EEOC matters. So it's something that we're excited about and we've been following EEOC quite a bit. We've been engaged on EEOC matters over the last year. We've learned a lot about what the new EEOC is about. We want to share a little bit of that and kind of look over the horizon to help employers really getting ready for what's coming up this year. So let's talk about how we want to spend your time, hopefully well today, with us for about an hour. First, we want to just unpack some of the changes at the EEOC itself. Who's there, who fill in that org chart, as they say, and talk about how it's operating. Very important. Want to talk about some of the new actions, and some of those are very recent, now that a quorum is in place. An update on enforcement, always critical, and end, as we try to always do, with some key takeaways, some practical points on what employers can do, how to best manage all of these significant developments. So, Nita, let me ask if you can just kick us off.
Absolutely. Well, let's start with, and we've talked about this before. Let's jump to the next slide. Who are we talking about when we talk about the commission? So we know that Andrea Lucas is now the chair. She was acting chair from almost the first day that Trump was in office. In November, she was made acting chair. She will be on the commission until 2030, unless she were to drop off. Then we have Kalpana Kodagal, who's the only Democrat left after the firing of the former chair and vice chair by President Trump. Kodagal her term actually expires next year, so it's kind of interesting. Maybe that's why they picked her to remain. And finally, we have the newest commissioner, Brittany Panuccio, who's also a Republican, and who, from her hearing and through what Leslie will be talking about in a minute, will follow in lockstep with the chair. There's no question about it. Finally, we do have a renomination of Carter Crow to be the general counsel. Carter Crow was nominated by the president to be general counsel in the fall, but as we know, when the end of Congress comes, they have to renominate people. So he's only been just a few months that he actually had been nominated by President Trump. And clearly, until the Congress can refocus on hearings, he will have a hearing at some point in probably the near future. One last data point is that the former OFCCP director is acting general counsel right now, according to the website, Catherine Ishbach, who we became somewhat familiar with. And with that, I think the important thing, one thing I did want to mention is in her biography, Lucas says that she understands that our nation's civil rights laws reject identity politics and instead focus on individual rights and equity. And I think we'll see that as we move through some of the commission actions. So, Leslie?
Can I just say,
I'm sorry, go ahead, David.
One comment on Mr. Crow before we move off this slide, because I think most folks are generally familiar with the three commissioners. Mr. Crow hails from Houston, Norton Rose firm, former president of the Houston Bar Association. His practice, interestingly, has historically been more focused on wage and hour, large pattern practice, systemic cases, but not so much in the EEO space. That being said, barring something unexpected, I think in background or otherwise, or in Senate confirmation, he should be a layup to be confirmed. I think it's just not a question of whether, but when. I do fully expect Mr. Crow will be coming online as the GC as we move forward. Leslie, over to you.
Okay, and I would say, I mean, that's not unusual. The former chair, Janet Dillon, was not an employment lawyer by training, and she went on to be EEOC chair and caught herself up pretty quickly. So, okay, so let's move to the next slide. Nita mentioned the president's actions at the beginning of, right after inauguration. He immediately moved Andrea Lucas to acting chair capacity, and a week later, he terminated 2 of the 3 sitting Democratic commissioners. That was a pretty extraordinary move, but that move not only prevented the Democrats from holding a majority in the commission during his term, but it also deprived the commission of a quorum, which meant that Andrea Lucas couldn't make any change to commission policy or process that required a commission vote. And we've talked about that before. And of course, that changed in the late fall with the confirmation of Brittany Panuccio, clearing, so it gave the Republican commission a quorum, a majority, and cleared the way for commission level actions. And as we saw over the last year, even the lack of quorum really didn't stop Chair Andrea Lucas from shaping the agency, even while serving as in an acting capacity. David, you mentioned, or Nita, you mentioned till 2030 she's in. That's because in the last year, not only was she serving as an acting capacity, but she also was up for reconfirmation. And yet she still managed to make a pretty significant imprint. The commission experienced a surprising amount of change in the last year, despite those constraints. Well, we're now in 2026. It's a different story. The acting title is gone. The commission's quorum's restored. And with those pieces finally in place, those of us who've watched the commission pretty closely, we really anticipated movement at the EEOC. And we certainly have gotten that in spades. Chair Lucas has moved quickly to consolidate authority and really to advance the Trump administration's priorities for the agency. Okay, next slide, please. Okay, so let's talk about what we've seen publicly, what's been released in the last few weeks. At the very first open meeting of the EEOC under the Trump administration, and that happened on January 14th. By a 2-to-1 vote, the Republican majority eliminated the timelines commissioners previously had to review materials before voting. And those timelines were designed to ensure the commissioners had sufficient time to review and comment on guidance on votes on whatever. I mean, some commission documents are pretty lengthy. So that's gone, at least for now. The bullet before that, the majority also rescinded a really significant aspect of the commission's voting procedures, and that's the ability of any commissioner to agenda an item. And at the commission, I think, as Vicki Lipnick likes to say, we used agenda as a verb. Agending an item required the chair to sort of stop the process and required the chair to hold a meeting on the issue, public or open or not, depending on the issue. In practical terms, what these meant is that the chair couldn't simply move forward with the item. They either had to hold the meeting, negotiate with the commissioner, outweigh the commissioner, or drop the issue. And so these procedures ensured that every commissioner had time and leverage and a meaningful role in the decision-making process. And I just wanted to explain why this is important. But it's important to note that these practices were longstanding norms. They were not written rules until the very end of the Biden administration, in which they codified the rules. And so what Andrea has done here is she's gotten rid of those rules. and she said that she intends to issue new timelines, and she'll grant agenda requests when feasible. But she also emphasized the need for flexibility to manage the commission's agenda. So that framing in itself provides insight into the commission's business and where it's heading. Commissioner Kodegal raised some objections and proposed alternatives at this first meeting. And that's where Andrea provided this criticism. The elections have consequences, which incidentally is one of my least favorite statements ever, going back years as a Washingtonian. But in any event, that being said, that this was within her right to do so. And so that is the first vote, and that's why that mattered. Next slide, please,
Leslie,
Sarah. Yeah,
yeah, Leslie, one thing that it felt like before we go to the next slide, it kind of
yeah.
felt like to me that this is so before you had a commission of 5 commissioners with 3 in the majority and 2 in the minority, and there was an attempt to have everybody on board or have their ability to have a say. And basically, am I wrong in saying that this kind of eliminates that?
Well, it certainly gives the appearance of eliminating it, but they were, it really kind of depends on, we don't know for sure. It certainly feels that way. And Commissioner Kodegal suggested that, but it could go any way. I don't think it will. It it's moving from a commission to more of an executive branch agency, which we've heard about, and we will, the thrust of some of these changes. Okay, next slide. Okay, so you might have heard folks talk about the delegation of litigation authority. It was the first thing people came and talked to me about when I was at the commission. You have to leave it alone, all that. A quick bit of history on this. This dates under Title VII. The commission has a right to vote on all litigation, and that changed in the 1990s. Under the Clinton administration, Chair Gil Casillas, and the commission delegated a lot of its authority for litigation filing to the general counsel. And this was done to speed up litigation process, to get to litigation, and to provide the EEOC field with greater agility. Now, over time, how that's evolved is it's changed in bits and pieces. Like, for example, when I served on the commission, we also had a vote on every ADA case because the ADA was a pretty complex and relatively new law. So, but even then, we had limited visibility and influence over what the commission was often litigating. We would read about it in the news. In fact, my former fellow commissioner Paul Miller, may he rest in peace, used to say we had a lot of apparent authority, but no actual authority. I think that was a slight exaggeration. If you knew him, it was a perfect comment. Um, Now, at the same time, the chair has always exercised a substantial authority over litigation. They've always known what's going to come up to the commission. And the career staff has long supported the delegation of authority. And as a result, that basic structure had stayed in place, since it was put in place in the 90s. And the first major shift really happened under Chair Janet Dillon, who I mentioned previously. She made big changes to the delegation, which I thought greatly improved it for the commissioners. And the types of cases they were seeing under Chair Dillon and how they were dealing with it is mentioned in the slide. They were seeing all the big litigation and really getting a chance to weigh in. The 2026 resolution, which was done by notation vote, and that means on paper and not in a meeting, is even a greater change. It expands the approval requirements to almost all litigation filings. In fact, the only area where the general counsel has sole authority to move forward without the commission is to enforce a consent decree or to compel compliance with record keeping or reporting obligations. They also included an expedited 5-day process for some matters. to ensure the commission would move quickly with some matters, but nearly everything will go before the commission. And the net effect is that the litigation authority has shifted decisively back to the commission, and that centralizes control with the majority. It means that anytime anyone in the field is thinking about proposing litigation, even for what they thought was a pretty routine, typical case, they have in mind that it's going up to the commission. And that's a big deal here because litigation is the agency's most powerful enforcement tool, or certainly the threat of litigation as well. And it's bringing nearly all things back up to the commission, and consolidates the decision making to the top, which, as we've said, is pretty much a Republican majority and far less of a commission where everybody's weighing in. David,
Leslie,
yeah,
you
Nina.
are the expert on systemic discrimination, because when you were at the EEOC, you were very involved in sort of
My
re-upping that.
my third child, Nita. Yes.
There's been some discussion in the press that this might seriously impact systemic litigation because it takes a while to develop, and the district offices may not want to be willing to take the time and effort if it's not going to go forward.
Well, I think that what will go forward is what's a preference of the chair. What we're seeing is the district office is still moving on systemic issues and matters, and putting pretty tight deadlines for big, huge requests to move forward. So I wouldn't say they're not moving forward. I'd say the creative aspects of them may not be moving forward. Things that maybe are what the field wants to focus on. That's my guess. I mean, I'm not there, but I hear enough to know. The field is still doing those, at least right now.
Well,
Okay.
and we know in the past the EEOC had gotten a little bit off the reservation, and in fact had a number of cases where they were required to pay fees to the employer.
Right. Yeah. I mean,
Correct. Where they were sanctioned by the
Right.
courts. And so
Yeah.
presumably, I mean, look, this is different and it kind of depends on which end of the telescope you look from. If you're a career person, you've had, years of autonomy or semi-autonomy in doing things. This may feel like a bit of a harness saddle that's been put on you. On the other hand, if you're at the chair and the commissioner's level where you're held accountable for what your agency does, knowing what the most significant decisions, which is when you're going to sue an employer, that is the ultimate use of the agency's power. When you engage in litigation like that, there is, I think, a meaningful case to be made for doing that, but
let me add
may
one
have a
more
lot of
thing. I mean,
practical implications.
yeah, now as employers, we know everything goes up to the commission, so there's sort of a chance for employers if they, want to appeal in that way. I mean, there's just more room, there's more
Right.
certainty of the process because
Well,
we know
I was just
exactly which cases
yeah, and
go.
certainly
It's
many
all
of
of
us
them.
have encountered the challenge if you have uh, uh, intransigent regional or district representative who says, I have the ultimate authority here. Well, sometimes that's not always in your client's interest, and it can lead to sometimes some, we believe, untoward results. So I hope
Yeah.
overall this will have this. There are lots of twists and turns in this, and it does present additional opportunities for employers. If
Yeah.
they're facing litigation, you do have various levels and components of the commission to confer with. So I think those are some important takeaways here.
I mean, I'm a supporter of restoring the litigation authority generally. I really am. How
Yep.
it's used is a different story, but we'll see. All right, Sarah, next slide, please. Okay, so January 22nd, at last week's commission meeting, the majority voted 2-1 to rescind the EEOC's 2024 harassment guidance. This was a very comprehensive 150-page guidance. It was nearly a decade in the making, and it was building on the incredible work that Commissioners Lipnick and Feldblum did through the Select Task Force on Harassment. And what they did in this guidance is they consolidated and replaced multiple pieces of the commission's harassment guidance. There were separate guidance in lots of places, one for supervisors, one for employees, and updated the guidance. And some of these guidances dated back to the 1980s. Now, as many of you know, part of the impetus for the vote was a Texas federal court decision that vacated the LGBTQ examples in the guidance. The ruling did not invalidate the whole document, and in fact, it had been grayed out on the commission's website, very specific pieces of the guidance, but it did create some uncertainty. In fact, Chair Lucas had previously voted against adopting the guidance based on those examples. However, she had indicated she was very much in favor of aspects of the guidance. So what surprised most of the observers for this commission meeting was that the commission didn't simply revise or remove those examples, and instead it rescinded the entire guidance. And there was no indication from Chair Lucas at the meeting that a replacement harassment guidance would be issued. That was probably the most shocking, because I think by the time we got to the meeting, there was notice that it was going to be rescinded. But we all expected that they would discuss that. And Chair Lucas and Commissioner Panuccio, and it's frequently what you see is the chair kind of calls the meeting and the another member of her party kind of does more of the explanation. So Panuccio spent more time sort of defending the action at the meeting, but both of them explained that their primary rationale was that the EEOC lacks authority under Title VII to issue guidance. Now, it is true that the EEOC does not have formal rulemaking under Title VII. It only has procedural rulemaking. But historically, the agency has played a critical role in issuing interpretive guidance. And that guidance was relied upon by EEOC staff, like the investigators during the investigation. Employers look at it. I used it as a monitor, and employee and their counsel look at it. So to suggest that this is too far was a lot. Viewed in that light, the action was not just limited to the LGBTQ examples or the Texas decision. It reflects a broader view that about the commission's authority under Title VII. The net result of this is a significant vacuum. The absence of a unified agency-wide framework for analyzing harassment claims. At the meeting, Commissioner Panuccio said that the private sector could step in, and there was already the court cases, but there's so much in that guidance and so much established EEOC precedents that I think people will be pulling out their old copies or looking elsewhere to kind of see where the commission was on this, and I don't know what will happen in the future. And really, all of this raises a broader and serious question. If the commission lacks that authority to issue harassment guidance under Title VII, well, what does that mean for the other existing guidance under Title VII? There's guidance on race, on national origin discrimination, on religion. In fact, Andrea Lucas spent a lot of her time working on that guidance. So there are lots of legal and practical consequences there.
I think, Leslie, I agree with that 100%. I think the legal term for what occurred here is throwing the baby out with the bathwater, right? I mean, it's just, it wasn't a scalpel, it was a sledgehammer. But without minimizing the loss of practical points on harassment, your broader point of all these other guidances, there is this very comprehensive, and I think most sophisticated employers understand it's not a regulatory requirement, but it does provide useful, practical guidelines for people to steer their compliance towards. And again, the courts, let's face it, the courts now, we know that Chevron no longer exists. It wasn't regulatory guidance anyhow, but there was at least arguably Skidmore deference that might have been paid, low-level deference to the courts. It's helpful. It was helpful. That's all. And at a minimum. And there's a lot of practical aspects. I thought that the comments on the efficacy of guidance and the authority to issue guidance potentially long term may have some significant consequences. The loss of this guidance is problematic. It would seem to me a little unnecessary, but it is what it is, and we march forward.
Can I add that this issue had come up when I was on the Hill. I was also labor counsel before I was at the EEOC. And there's a balance between, what the EEOC tries to do with these guidance. And we as employers don't always agree with everything that
Right.
EEOC puts in the guidance. But if you just rely on litigation, what you end up as an employer with is a gotcha situation. Employers
Yeah.
want to know where EEOC is in the law. So without that guidance foundation, there we don't know for sure. We can only look at the EEOC cases because we can't look at every case across the country and know, and
Well,
EEOC doesn't always follow those.
and a final point, it leaves the clients, our clients that are multi-jurisdiction employers, worrying about, well, how does the Fifth Circuit view it? How does the Ninth Circuit view it? How's the First Circuit view it, et cetera? I mean, compliance has become much more challenging, both legally and practically, I think.
Well, and I think we have to add, we still have Loper Bright issues, which
Right.
without the guidance to at least for the courts to turn to, as the Supreme Court did in the Goff case and said, the EEOC guidance on religion was right on point.
That's right, Nick.
It's going to make everybody's life much more difficult.
I agree.
So I'm going to go to the next slide. And, now that we know, so as Leslie was talking about, under Title VII, generally the EEOC does not have the right to issue regulations. That is not true for the Pregnant Worker Fairness Act. They were directed to issue regulations, which they did. And those regulations, like the harassment guidance, have been under attack in various courts, and primarily over abortion, one of our favorite issues as a country. And a number of courts have blocked the enforcement of the abortion accommodation requirements that are laid out. In addition, off the topic, you also have Texas is trying to declare that particular law unconstitutional based on the way it was passed, with not everyone actually at the Congress when it was passed. But I think what we can expect next is they're going to have to go through notice and comment to make to eliminate the current regulations and issue new ones, because they have to issue regulations according to what Congress requires.
Yeah. So they have to go through a rulemaking. The question is, are they going to just go to those very issues that were an issue at Texas, or are they going to take a scalpel to more of it? And normally I would say they just go to those issues, but given the way other things have been handled, I suspect it'll be there'll be broader changes too.
Right. We will see. And obviously, the
Yeah.
opportunity to file comments is one not to be ignored. There's likely not to be an extended period. Could be as short as 30 days, more likely, I hope, 60 days. There's some discretion, but that is something that certainly for clients that we are looking at carefully and will be likely filing some thoughtful comments to address these issues.
So David, you're up next.
Yeah, so just just to sort of close this block off, and the next slide, the what do we what are the takeaways from what's developed over the last last month or so of activity as we see the commission now getting fully staffed up with a quorum? First of all, Leslie's done a great job in describing all the different ways in which authority has shifted both within the agency. So we have a consolidation at the top of the agency. But importantly, it begins to start to line up the agency in more of a typical executive branch agency. And you can hear in Leslie's comments the shift from a commission with 5 members, with each commissioner in different views and majority, minority views, et cetera, collaborative, sometimes not collaborative, but that's been the history of this and other commission quasi-independent agencies. Now the agency, without a change in a single comma in a statute, the agency is becoming much more of a typical Article 2 executive branch agency, accountable to the White House, accountable to the president, with strong centralized control and direction down to the career people. And I think that if anything, I think we're going to see more of that, not less of that, both within EEOC and some of these other agencies as these changes occur. The commission review of litigation, like I said before, that's the most significant decision, in my opinion, that the commission undertakes, whether to commit resources and to go to court to seek to allege that an employer has violated the non-discrimination laws and to seek relief on behalf of individuals. That authority and how it's now going to be framed with accountability to the commissioners who are answerable directly to Congress and the White House. That's what this is about going forward. And I think we're going to see more, if not less. That also means we can look at the White House's stated policies, which, and we're going to talk a little more about this, have been embraced and will be reinforced by the EEOC as a functioning line agency within the administration. Anything on that, Leslie?
I
Yeah.
have one more thing to add. I was thinking about this. So one other aspect of being a commissioner and having a vote is that once it's been voted on, you really don't have a say as a commissioner on appeals, what the commission is going to do if they lose. And so it mushrooms from there, the lack of control on policy. So I think the chair gets a little say on that because they talk to the general counsel. But again, all of this is really consolidating this at the commission, but for the majority of the commissioners, so it goes back to the chair. And we'll just have to wait and see how this goes.
One last thought, David, before we go to the next thing, is this really, when Lucas said in the hearing that elections have consequences and that they're going to move forward rapidly to, move forward on Trump's agenda. I mean, I think that's really what this is all about, which is what we're going to talk about next, actually. So let's go to the next slide where we're going to talk about startup enforcement. So the first thing is one of our favorite topics, which we've talked about a number of times this year, illegal DE&I. And I think what's really interesting is as you read Chair Lucas's most recent missives, she's been quoted, she's been in Reuters and others have done interviews with her. She's tightening down on what they consider to be illegal DE&I. And basically, as David stated early on, they really, if there's anything that has race or sex tied into it, you are likely to find yourself on the wrong side of an EEOC investigation, especially if a white male has complained about it. And so let's talk about an example of a current EEOC investigation against Northwestern Mutual. This is a case where a white male, Mark McNulty, a white former anti-money laundering officer, complained. He had filed a charge complaining that he was discriminated, he and other employees were discriminated against because they were not provided additional support and promotional opportunities that were provided to women and people of color. Very much a DE&I kind of a focus. The response, however, by the company is not what we would recommend, and I'm sure Leslie and David would agree with this, is the company basically did not, so the EEOC sent an RFI. The company did not provide all the information they wanted. They subpoenaed the information, and the company still didn't provide all the information that the EEOC wanted. So they've now filed a subpoena enforcement action. And the companies objected to the request as too indefinite, and they demanded that the commission identify what parts of the initiatives violated Title VII. None of these things or none of these complaints, they also refuse to allow EEOC to interview the DE&I officer of the company. They are, subpoena enforcement actions are not like anything that many companies ever seen. I had the unfortunate situation of being at the wrong end of one where my company went in and said, why do we have to provide something we don't actually have to the agency? And the judge said, why haven't you already provided whatever EEOC wants yesterday? And Leslie, you know this better than I do.
The EEOC has broad subpoena authority. That doesn't mean employers generally turn over every single thing in an RFI, but we are seeing a very aggressive moves from the EEOC, particularly in this area. So it's challenging. It really is. We're going to talk about that a little on the next slide, but was there anything else you had to add here,
I just
or?
one thing I wanted to mention, this PSA ad that caught a lot of. I mean, part of what the chair wants to do is promote awareness of the EEOC. Well, it promoted awareness. Now it caught some negative feedback as well as positive feedback. But I would encourage folks, if they haven't looked at it, take a look at it. It is an explicit shout out to whites that if you've been overlooked, you don't know, EEOC is here for you, is the gist of the announcement. Interestingly, just as a little kind of footnote, Stephen Miller, Mr. Miller, who's the domestic policy advisor in the White House, who I think everyone is generally aware of, when he was heading his former organization, America First Legal, scripted out a very similar ad. And I think it's fair to say these are almost spoof-like ads off late night TV, used car salesman, sort of shouty with an 800 number. And if you go to YouTube, if you're interested, you can find Mr. Miller's ad. And if you're a real geek, as some of us are, if you run them side by side, they're remarkably similar. It is noteworthy that Chair Lucas's PSA announcement was promoted widely by the administration, including by the president on Truth Social, by Mr. Miller, by the vice president, etc. That does not happen every day with EEOC initiatives. So there is a point where, again, trying to demonstrate that you are aligned and a successful administrative agency, I would say the PSA ad went a long way towards doing just that.
And David, one other thing I wanted to mention is shortly after this PSA was put up, the president, in a long series of interviews with the New York Times, said that he felt that white people had been badly treated by the Civil Rights Act of 1964.
Yes, indeed. And for those that are interested, our most recent podcast that is posted, we actually delved into all of that and have some additional analysis. So I'll kind of refer people over to that podcast. If you're not there, DC Insider Employer Update, check it out. But we spend a whole podcast talking about what this PSA announcement and what the current initiatives may mean. All right.
Leslie?
Okay. I wanted to add one other piece. Of course, we don't usually know what's happening in EEOC investigation because investigations EEOC can't reveal. But when it comes to not just a subpoena being issued, but a subpoena enforcement action, that's when they are disclosed. So that's why we know what was happening behind the scenes with Northwestern Mutual. Okay.
And yeah, final thing as we move to the next slide, I think that most employers would try a little more successfully to try to negotiate when you get an RFI that you think's over, that you don't ignore it or make counter demands. That's normally not a successful strategy in our experience. But all right, well, let's look at the next slide on religion.
Yes, and this comes to play in religion and the anti-Semitism issues that we're going to talk about. Now, religious liberty and anti-Semitism has become a clear enforcement priority for the current commission, of course, and the federal government. In fact, the chair released a document last August, that 200 Days of Religious Liberty report, where it emphasized all the commission had done in the first 200 days of the administration, on these issues, it focused heavily on religious accommodation, and it pointed to different matters. There was a lot of cases on behalf of anti-vaxxers and other religious accommodations. It also pointed to the $21 million settlement EEOC was involved with Columbia University, and that had resulted from a commissioner charge that Andrea Lucas had brought following October 7th while she was still a commissioner under the Biden administration. But the EEOC's resolution is pretty unusual because it was part of a far broader settlement with the Trump administration, and it wasn't a standalone EEOC action. And in fact, the only part of the settlement, is my understanding, because we've actually never seen that agreement for sure, that EEOC is involved in, is handing out the money to the folks that were impacted. So all the other aspects of the settlement are handled by Department of Justice. Now, during the investigation at Columbia, it wasn't revealed at the time, but controversy arose over EEOC's collection and use of personal contact information for Jewish faculties, employees, and student employees. And although the EEOC routinely requests personal contact information, and it does so to avoid reaching employees at work because they feel that they won't talk to them. The outrage in this case, again, the investigation was not disclosed, but suddenly these employees hearing from the EEOC at home generated a bit of an uproar, and it raised broader concerns about investigative boundaries and privacy. The employees were saying to Columbia, why did you disclose that? That episode highlighted, and it happens also in the private sector, that tension between aggressive systemic enforcement and individual privacy protections in highly charged environments such as that. And more recently, we are really seeing that come to play at UPenn, which incidentally is, I believe, I was thinking about this morning, Andrea Lucas's alma mater. Recently, EEOC moved to compel a subpoena enforcement in a similar investigation at UPM, and EEOC had issued a subpoena in that. It also, I believe, came from a commissioner charge from Andrea. And while UPenn was willing to give over a lot of the things the EEOC asked for, it pushed back and said it wouldn't give the names or contact information of Jewish faculty and staff or information on Jewish-related groups and programs. It said it was not going to identify individuals based on religion or expressive association. And it offered alternatives such as notice-based alternatives. Well, EEOC went to court and enforced that subpoena. UPenn is fighting it, and Penn faculty and student groups are intervening. So are other groups like other associations, and it's raising concerns about the privacy sensitivity and the potential misuse of religious and associational data. And it's a core dispute. It's not just access to the complaint information, it's whether the government can compel an employer to identify individuals based on religious identity or protected associations. It's really triggering First Amendment privacy issues. And we said before, EEOC has broad subpoena authority. I think this is really going to put the rubber to the road on that, and we're going to see how broad it is, and when does one right clash with another. Does anybody have anything else to add on this, or shall we move on?
I think we need to move on because
Okay.
we
running out of
are,
time. Yes. Yeah. Okay.
As we always do, Mr.
As we always do. Yeah.
Okay.
Because there's so much to talk about.
There's a lot to talk about, and we're spirited about it. Well, let me just say a couple words about what's called Project Firewall. Project Firewall is a multi-agency. So again, one of the themes is that the agency, not only is the EEOC part of fully part of the executive branch, Article 2 agency, as opposed to this quasi-independent. But it's much more, it's always been integrated to some degree, but it's become much more integrated with other agencies, particularly the Labor Department and the Justice Department as their natural partners. Project Firewall really builds on that level of integration. It's a DOL led initiative, but it involves both labor, EEOC, as well as the Justice Department. It is focused on effectively national origin discrimination. So you can appreciate that is in discrimination against American workers. You can appreciate the EEOC's part of that. The Labor Department, their angle comes in on the H-1B visa process. In order to procure an H-1B visa, an employer, among other things, files an attestation that they are not able to procure the necessary skilled worker from the American workplace that they've advertised they can't find, whether, think of a software engineer, one of the most common uses of H-1B workers, not exclusive, but they've advertised for that. They can't find them. And now they need to bring in and have visas issued that allow non-Americans to come in to hold those jobs. That has been a longstanding practice. There were a lot of H-1B workers used. And what is now happening is in the Labor Department, it used to be that individuals would have to file charges under the H-1B program to be investigated. The Labor Department has honed in on a statutory authorization that actually allows the department to initiate charges or claims akin to a commissioner filing a commissioner's charge under Title VII. So now the Secretary of Labor can do that. Well, we don't have publicly available statistics on how many of these have been pursued within the last 30 days. By the end of November, we know that over 200 investigations had been opened by the Labor Department. As part of this, the Labor Department has said that if they come across any information that suggests there was unlawful employment discrimination, that will be referred to the EEOC for follow-up action. And then potential citizenship discrimination also is actionable by the Justice Department. Let's look quickly at the next slide to get a take on how EEOC is leaning into this. So the very first settlement that when Chair Lucas was acting chair about a year ago was against the Leo Palace for $1.5 million. It was discrimination against American workers. That was the first major settlement out of the box by the Trump administration, EEOC. The EEOC has more recently published new materials. Substantively, they're not breaking any new ground. It is still Title VII national origin discrimination, but there's a lot more energy and focus. So think of the EEOC now as having several feeder pools, if you will, through cognizable claims. The Labor Department conducting hundreds of investigations into H-1B. The EEOC through charging parties, and I anticipate commissioners will be opportunistic, certainly the chair and her fellow Republican commissioner, if they find a basis on which to file commissioner's charge to pursue. This is a very high-level priority for the Trump administration, and we're seeing the EEOC as among a three-legged stool or agency approach.
I think one thing that was interesting that was in this document, which you can find on the EEOC's website, and you can link, we have a number of links in the slides as well, is that Lucas points out that ads that say you prefer H-1B employees is discrimination, according to her. And in addition, that if you require that people can file charges. Leslie?
I'm not aware of those ads. I don't know if they are commonplace. I mean, I maybe David, but I think what's new about this is EEOC has used national origin, often in the past. What they've never done is used a national origin to focus on discrimination against Americans. So that
I
part is new.
just will divert with one brief historical anecdote.
Yeah.
In the Biden administration, when we had an OFCCP, we were involved in a very significant OFCCP investigation led by the the Obama OFCCP, it focused exactly on these claims. It focused that a company had discriminated against Americans in the overuse of H-1B workers.
Yeah.
So it's interesting to me that both the Biden and the Trump administration, it's kind of like you go around the barn different ways, we're at exactly the same point that's being articulated. So we'll see how this plays out. I do think there's a lot of energy on this, certainly from the Labor Department leading the charge. Andy Rogers at Wage Hour, Keith Sonderling, Deputy Secretary, and Andrea Lucas, and they keep calling each other out in press releases and reinforcing each other, which I think is fascinating and important.
Absolutely.
All right.
And Department of Justice has also pursued this issue before as
Absolutely.
dealt with.
Well, they have a whole different act. They have the,
yes,
citizenship
The citizenship.
discrimination.
So they have a role too. Yeah.
yes. Okay. Next slide, please. Okay, so what are we seeing for EEOC? Even with the structural changes we've discussed, the EEOC continues to enforce the core federal anti-discrimination laws, but at a noticeably slower pace. In fiscal year 2025, EEOC filed the fewest lawsuits it had in a decade, and the implications of that are not entirely clear because, let's face it, the commission lacked a quorum for much of the year, and that means that it had limited authority to initiate new litigation. And as we know, it also declined to pursue certain categories of cases and actually withdrew from cases. Clear examples of that have to do with declining to investigate or litigate cases based solely on the disparate impact theory or the LGBTQ, the transgender related claims. It withdrew from those. At the same time, the commission continues to bring, some of its bread and butter cases, of course, harassment, disability matters, traditional sex discrimination claims. We've seen race discrimination claims. And as we've discussed, it's vigorously pursuing religious discrimination claims. So those remain pretty alive and well, despite what folks say. Now, looking ahead, the commission did take a bit of a cut in its fiscal year 2026 budget, but that was 5%. It was predicted, I think, with all the retirements, the commission can certainly handle that moving forward. It means that it'll make more decisive, choose wiser and more carefully, really highlighting again the chair's ability to pick her priorities. And also I wanted to add that Congress added this language requiring EEOC to notify Congress if it was going to make any structural changes. And so that's really introducing perhaps renewed congressional oversight, which we have not seen a lot of this agency, which we haven't seen a lot of in this administration. But whether or not that has teeth or is really performative, we'll have to wait and see.
One quick thing, I did do a quick survey of the press releases since the beginning of the fiscal year. And so far, they have 2.6 million in sex harassment cases, 1.155 million in disability cases, and 4.335 million in sex discrimination cases.
So settlements since the beginning of the year?
Those are all settlements that were announced.
Okay. Thank you
So,
for
David,
doing that.
we're running out of airspeed and altitude
so they continue
here.
to be active, but let's hit our key takeaways. And jump right into them because we want to sort of divine a little bit of the practical aspects for folks as to what all these different developments mean. Leslie, let's ask you to kick off the DEI.
DEI. Okay, this is one of the things with the quorum. That means EEOC can bring new cases that hadn't brought new issues before, and we're going to expect to see that in the DEI area. And really, we're going to see, we think, maybe issues brought up about how protected status is used as an organizing principle and whether or not it violates Title VII. And by that, I mean For example, how employers are using protected status to create affinity groups. Will that alone be enough, even if they're open to all?
Yeah.
So that might be an example of something that we thought was absolutely fine if you complied with what the commission had said was okay, that you could move forward, and now we don't know. David, do you have anything to add on
I
that?
think I just quickly, I agree with that, and that's an area that we're certainly watching. Second, we are seeing and hear from others that there are a number of larger, high-profile employers that have had historical, rather modest, kind of what it would appear to be one-off EEOC charges that are pending that have now been very recently revamped to be investigated as much broader corporate-wide or systemic-wide investigations, coupled with very robust RFIs and so forth. So the commission, that may mean that their inventory of new DEI claims isn't what they'd hoped. You connect the dot between the recent PSA announcement
Yeah.
and what we see. But it does mean that they're going to continue to pedal hard to try to get that. So I think employers are well counseled to pay ongoing. This issue is not dead. It's one of the top
Yeah.
priorities. Continue to monitor the website. We continue to have clients that have well-intended, spirited employees that even though they think they've sort of aligned their DEI programs, it sort of, if you will, breaks out. And so monitoring that, knowing what's there. A lot of our clients are facing these survey requests. Will you jump
Yeah.
in and share your data? That type of thing. I think that Chair Lucas has made clear that that is potentially a very significant enforcement priority. If you're using data, EEO workforce data like that, she believes that that is problematic. At a minimum, whether it is or isn't problematic, it's more likely to catch attention, negative
Right.
attention by the EEOC, which most employers don't want.
Religious accommodation process, you really need to look at it and make sure that you're accommodating all of your employees as best you can. At least go through the interactive process and all that. We have not gotten any additional guidance and probably aren't going to get any additional guidance after GOF. But at the very least, you need to look at it and stay on top of it.
Agreed. H-1B, we've touched on that. The H-1B is not an area that most EEO compliance personnel have paid much attention to be honest, nor have most people, in my experience, paid much attention to national origin discrimination. I would just suggest listen to the message from this administration. Anything that can be challenged as being, quote, anti-American, close quote, is a top level priority item for multiple agencies. So again, this is something that I think if you have been in the past a user of H-1B talent, particularly, I would look carefully at what you've done. You can't necessarily unring the bell, but I'd make sure that going forward, if you have problematic practices, you have addressed those.
I think training for management employees needs to be one, you need to get rid of any training that might violate the DE&I requirements, the guidelines that we've gotten so far. But also, I think employees and management need to understand what the new world order is. Even though they haven't changed the law, they've changed what they're going to focus on. And especially, do not ignore white men who complain about things. Go through the same process with them that you would go through with anybody else. And I think that's really important.
I agree. And EEOC does, in my experience, focuses on training quite a bit. Final thing, there's been a lot of murkiness on should you not collect EEO data. We know that the EEO1 form currently is in effect. We anticipate it will go forward this year. So that's with respect to your workforce, an obligation to file the EEO1 report. But what about with respect to applicants? Many employers are federal contractors. You formerly had an obligation to ask applicants to voluntarily and job seekers to voluntarily provide that information. We still believe it is a best practice to continue to do that. Chair Lucas, she's very specific about what you can and cannot do. She agrees that there's no prohibition on the voluntary collection of the data. Her cautionary note, and it's one that I share, is it depends on what you do with the data. Specifically, she believes that if the data is properly cabined and used by legal and by the HR in order to assess compliance, to see whether the current practices, et cetera, are resulting in adverse selection decisions, et cetera, that is a proper use so that remedial steps can be initiated and taken. What Chair Lucas believes is an improper use, though, is the wide dissemination of that data, say to managers. You have 22% representative of engineers, et cetera, of this race or ethnicity. And so I think the ongoing collection and use of data, being careful, but is still very much essential, although no longer required.
Okay,
Leslie,
last thing.
speaking of
We
data,
learned very recently that EEOC was subject to a data breach. Now, this is significant because the EEOC has never had a data breach before. And it's significant because the data breach happened last February and EEOC found out in December. Other agencies that were part of the breach knew about it. EEOC did not. And some information got out there. We've already seen a class action based on it. Some of our clients are hearing that their data was breached. It's an issue, and it's most important for employers because EEOC asks for a lot of PII information, security code, security numbers, and all of that. And this is a reason for employers to push back in subpoena enforcement.
thanks. I'll just give a quick shout out. And Sarah, I see you're on, so I know we're out of time. But we do have a pretty robust resource page to try to help everyone on compliance issues, particularly the podcast. I'll just note that the DC Insider Employer Update on November 19th, we had Chair Lucas as our guest. And it's an extended podcast. It's a long discussion with Chair Lucas. I think there's a lot of good information, and she's just very natural on that podcast. That's exactly who she is. It's a very useful tool. I think anyone focused on compliance would be well served to spend some time listening to that. Also, our most recent podcast, as I noted before, we did unpack some of these developments in a little more detail on some issues, and so I would encourage you to jump in on those. So with that, thank you both, Leslie and Nita. Great discussion today. Sarah, take us home.
Okay. We would like to thank you all for joining us today. If you have any further questions, please email us at info@FortneyScott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended and will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.